Well, welcome everyone, and thank you for joining me for this discussion today about how to protect your assets from long-term care costs. Hi, my name is Lynn St. Louis, and I'm an estate planning and elder law attorney, and I'm the founder of Elder Law Group. We have offices in Spokane, Tri-Cities, and Seattle. I really appreciate you joining me today, especially the live audience. If you have any questions, please put them in the chat. What we're going to be talking about today is Medicaid, Medicaid benefits, Medicaid asset preservation strategies. And I have to tell you, this is one of the more complicated areas of elder law. And if you have questions, that's going to be no surprise to me, because it is really a complicated area of practice. I'm going to do my best to make it understandable so that you can have a better concept of what Medicaid is and what you can do to protect your assets from devastating long-term care costs. And if you stay with me to the end, please do so. We'll be sharing some more information and some gifts with you. So let's go ahead and get started. What I'm going to do, because Medicaid is really such a complicated area of practice, normally what I do is simply talk, but for today I actually prepared a presentation to try to give you some visuals, some information visually to help convey the information. So I'm going to share my screen. All right, so we are talking about what we at Elder Law Group call Medicaid asset preservation strategies. The reason that we call that, we use that term, is that we are assisting clients understand Medicaid's rules and what their rules are to allow them to keep more assets and not go broke. No surprise, long-term care is expensive and it can easily deplete anybody's savings in short order. It can run $10,000 a month, $12,000 a month, even more. So that's per month. So a long-term care event could be $150,000 a year. And understandably, people get very concerned that if that happens to them, well, they don't want to become broke. What can they do? That's what we're going to be talking about today. What I want you to understand, and I have to kind of preface this whole discussion, is that in order to do the types of strategies I'm going to share with you, there needs to be in place estate planning documents that grant certain levels of authority that are something that an elder law attorney can utilize to do these types of strategies. This talk today is not about what estate planning documents you need. There's plenty of other talks where we've discussed that. But I just want to let you know that in order to implement these types of strategies, we need to have in place estate planning documents that allow these strategies. If you have any questions about that, of course, we're happy to help you at ELG Estate Planning. I'm not going to spend any more time on that right now. But let's go ahead and talk about Medicaid. So one of the things that I want you to be aware of, and there's understandable confusion about it, is what Medicaid is. Medicaid is a big federal government program implemented by the federal government, implemented by the state. What it covers, and this is, Medicaid is the main payment source for long-term care. Lots of times people think, well, doesn't Medicare cover long-term care? No, it doesn't. And people are unpleasantly surprised when they find out that their Medicare might cover their hospital and their doctor and maybe up to 100 days in skilled nursing rehab. But if they cannot go home and they have to stay in a care facility, or they can't care for themselves, they're going to be privately paying for that, because Medicare does not pay for long-term care. So that's one of the first very important things I want you to understand. Medicaid in the state of Washington is known under the term Washington Elder Health. So there are Medicaid programs for medical insurance, I'm focusing only on long-term care right now. And it's intended to help people who have a need that is covered by the program. What kind of need is that? It's for elderly and disabled people, people that need help with what's called ADLs, of activities in daily living. And there are different rules for couples versus single. There's resource rules, income rules. We're going to be talking about all of those rules as we move forward here. So this is the easy one typically, which is, okay, do you meet the Medicaid eligibility test for medical help? What that means is that the person who would be eligible for Medicaid benefits needs help with their activities of daily living, at least 2 activities of daily living. And as you can see, that's eating, bathing, dressing, transferring, toileting, basically walking around, movement. Also, if there's significant cognitive decline, then that may also qualify somebody for the medical test of Medicaid eligibility. So that's so far, that's the simplest part. Next is the resource test. Let me back up a minute. There is a financial test. The financial includes income and resources. The reason I didn't even put a slide here as income is it's such an easy rule in that in the state of Washington, if your income is less than your care costs, you qualify for Medicaid from an income perspective. So let's say your income is $5,000 a month. And let's say you are in an adult family home and that costs $7,000 a month. You meet the income test. State of Idaho, and we do practice in the state of Idaho as well, has different rules, and I'm not going to focus on those today. We're really just focusing on Washington's Medicaid rules today. With regard to the income test, let's say you are in a skilled nursing facility and that costs $12,000 and your income is $10,000. You qualify. So that's what I'm saying, is that the income test is pretty easy to meet, at least in the state of Washington. Resources. This is where it gets a little bit confusing. So what we're going to be talking about is what resources or assets does Medicaid allow you to have and qualify for the Medicaid long-term care benefits program. If you are a single person, they allow you to have $2,000 in countable resources. We'll talk about what does that mean, countable resources. But from any way you look at it, $2,000 is not a whole lot of money. And interestingly, that has been the standard since 1989. It hasn't changed. Now for married persons, there's a different rule. The rule for married persons is that the person who is sick can keep their $2,000, but the community or the well spouse is allowed to keep more money, between $59,890 and $132,380. So if you are married and your spouse needs Medicaid, or you do, and one of you needs it, the good news is that you will not need to go broke before getting Medicaid. So we're going to be talking a little bit more about that. Why is it that Medicaid has this different set of rules for couples? Well, the reason is it's called the Community Spousal Resource Allowance. The state does not want to see the person who is the well spouse be broke, be impoverished. So that's why additional amounts are allowed for the well spouse. Now this $59,000 to $132,000, why is it lower? Why is it higher? It depends on where the care is being delivered. The higher amount is only allowed if the ill spouse is in a skilled nursing facility. The lower amount if they're in adult family home, at home, or assisted living. I want you to understand that there is a policy against impoverishing the well spouse in the community. What we're talking about here, though, are what are called countable resources. Not all assets, not all resources are countable. So your house, whether you're single or you're married, your house doesn't count. Now, if you are a single person, there is an equity limit, and that goes up all the time, 603,000 right now. So if your house is worth 700,000 and you're single, then part of that equity in your house is going to be countable. That needs to be planned for if we're looking at singles eligibility. But let's just take as a basic rule, the house doesn't count as long as the house is not in a revocable living trust. I got to tell you, Medicaid is full of really weird rules. Why should it matter if your house is in your name or in the name of your revocable living trust? I mean, it's the same thing, but in Washington, if your house is in a revocable living trust, you just took it from being a non-countable asset and you made it countable. So if we're going to be doing any kind of Medicaid planning, we need to take the house out of the revocable living trust. If you have a vehicle, it is non-countable. One car, not two. All the personal property you have is not countable. Be careful if you have titled assets like tractors, RVs, boats, motorhomes, those are going to be countable. Unlike your furniture and, piano, etc. Those are non-countable. When I say small life insurance policy is non-countable, I mean really small. $1,500 face value. So for the most part, life insurance policies are countable. If you have an irrevocable burial plan or policy, if it's irrevocable, it's non-countable. And then if you have a long-term care insurance policy, a partnership policy, that's also non-countable. So there are a lot of things that are non-countable, but what is countable is basically everything else. Your 401k, your 403b, your life insurance policies with cash values, your multiple vehicles, banks, investments, stocks, just about everything you can think of that would be, hey, this is what my asset level is, that's pretty much countable. There is one non-countable tool that's on the slide here. It's called a single premium immediate annuity. That's a very, very useful tool to make assets non-countable. And a little bit later on in the talk, I'll be showing you how that works. But it's really, really a very useful planning tool. So a lot of people, when they're thinking about Medicaid, they say, well, if I can only have $2,000, why don't I just give away the extra money? I mean, that does make sense, right? Well, Medicaid is ahead of you on that. They're going to say, if you give away money, you don't need Medicaid. Obviously, you had so much money, you gave it away, so no. You've probably heard of this. I'm sure that you have. Medicaid has something called a 5-year look-back rule. So when it comes to giving away assets, giving away money, if you do that 5 years ago before you file for a Medicaid application, great. Medicaid doesn't look over that horizon because most people don't give away their assets 5 years before needing care. They don't even think about it until that point comes when they actually need care. And then they start thinking about strategies that they themselves can implement. And they go, I'll just give away my house, or I'll sell it to my daughter for $1. That's not a sale, that's a gift, that's not going to work. When it comes to how Medicaid treats gifts that are within that 5-year window, when you file a Medicaid application, you must disclose what your assets are and what you have given away. And if you say, well, I gave away a certain amount of money, under my example here, I say 200,000, then Medicaid's going to say, oh, you gave away 200,000. We're going to impose a period of ineligibility. And it's calculated based on this number, 10,785. That's the current penalty divisor. It changes about once a year. This is new as of October 2021. So if you gave away 200,000, then Medicaid will say for 18.54 months, you do not get Medicaid coverage. You are not eligible. What are you going to do? How are you going to pay for your care? They will not even impose this period of ineligibility until you are down to $2,000. So you're down to $2,000. You have an 18, 19 month period where you have no way to pay for your care. What are you going to do? That's a problem. So when it comes to giving away assets as an elder law attorney who implements Medicaid asset preservation strategies, do not do it. Do not do it. Talk to an attorney who knows Medicaid, who files Medicaid applications, and talk to somebody who just doesn't do one or two. They should have a number of Medicaid applications under their belt, because this is such a very specialized and unusual area of practice. One of the things that people are pleasantly surprised to hear is that not everything that you give away is penalized. So I talked about if you give it away for more than 5 years, you're fine. Assets that you give to your spouse, that is not a penalized transfer. That sounds really good. The bad news is Medicaid counts all assets of both spouses. So giving it to your spouse doesn't make it non-countable. It just avoids the estate recovery that we'll be talking about. Giving your assets to your spouse doesn't reduce your assets because the state will count both your assets. Giving your assets to your spouse is really intended for future eligibility and to avoid estate recovery, which we'll talk about. Giving your home to your disabled child, assets to your disabled child, or giving your assets to a trust for a disabled person is allowed. There are really specific rules for what that trust must look like. So it's not something that you can just say, oh, I've already got a revocable living trust, I'll just add that person's name. No, that won't work. You'll need to see an attorney who specializes in Medicaid to make that transfer work with no penalty. You can also give your interest in your home to your sibling if you both have an equity interest and have lived there for a year. There's a caregiver child exemption, which I find it's a very difficult exemption to apply, but it totally makes sense. If your child has moved in and lived with you and they're living with you for 2 years or more, and that the reason that they did that was so that you didn't have to move out of the house, then the state says, you know, your child service should be recognized and you can transfer the house to that child, as long as there is no private pay period between when you move out of the house and when you do that transfer. And if you know anything about care in an adult family home or assisted living, there's something called a private pay period. So there can be no private pay period for this caregiver child transfer to work. There's also some programs that do provide long-term care benefits. The Community First Choice is such a program. And under that program, there's no period of ineligibility. So this really is something that many practitioners are unaware of, that you can give away your assets and qualify for the CFC program. You can be at an adult family home, and if you otherwise qualify for the program because of your income being under a certain level, less than what I previously referred to, and you will never need to move to a skilled nursing facility, you can give away your assets, qualify for the CFC. That's one Medicaid strategy. So it's something that as an elder law attorney, somebody practicing Medicaid, they should be aware of. And if you're talking to an elder law attorney, make sure you ask them tell me about the CFC program. They should know about it. Medicaid has a right to estate recovery for any assets that remain in the name of the Medicaid recipient. So for a single person, that means that it's very, very difficult to avoid estate recovery. Basically, the rule is you can't if you're a single person. You're a single person, the house wasn't countable, you went on Medicaid because the house isn't countable, you still have the house in your name when you die, the state will have a lien and will be able to recover against your house. You can't avoid a state recovery under, I'll show you a way to do it, but the general rule is you cannot. If you are a couple in the state of Washington, it is very easy to avoid a state recovery. All you need to do is put the assets in the name of the well spouse, the community spouse, and you have avoided the state having any right to any of those assets when the ill spouse dies. Why then do couples not avoid a state recovery? The reason is that they haven't consulted with an elder law attorney. It is not that uncommon for a hospital or for a care facility to say, looks to us like you will qualify for Medicaid. We'll just go ahead and file the Medicaid application. And you think, why not? Why should I even have to go to a lawyer if the hospital is going to file the application for me? Of course I want them to do that. Well, unfortunately, what will happen, even if there's no snags with the application and the ill spouse goes on Medicaid at a facility, is because the hospital did the work for you. When that ill spouse dies, you have not avoided a state recovery. They won't collect while the well spouse is alive, but they will later. And you cannot avoid that estate recovery if you have not put the assets into the name of the well spouse from the ill spouse. I mean, nobody told you that you should do a quick claim deed on the house, removing the name of the ill spouse and putting it only in the well spouse's name. Nobody told you that because a lawyer wasn't involved and the hospital did the application. So be very, very cautious with who is helping you with your application. It should be a lawyer, an elder law attorney, and one who specializes in Medicaid. And that way you'll be able to protect your house and not lose your house. I mentioned when we started that for those of you who stay with us, you are going to be receiving some gifts. One of the gifts we are going to be sending you is what I just talked about, but in way more detail. It's basically the Medicaid's rules, and I'm just going to hold it up to the camera. I know you can't read that, but this is called an ebook, and we'll be sending it to you. So everything I just talked about with, well, not everything, but a lot of what I just talked about with Medicaid's rules will be there. And that will be something you can refer to. And I think that that will help with clarity of understanding about Medicaid's rules. Now, do I expect that in 25, 30 minutes of talking about Medicaid and you're reviewing the ebook I'm sending you, you're going to know Medicaid's rules? Of course not, but at least you'll have some better working understanding than what you started with. Okay, let's move on. Medicaid asset preservation strategies for a married couple. What I'm going to be talking about isn't how you can protect assets for your spouse when one of you has died. That's all part of estate planning, asset protection, trusts, in wills, that sort of thing. That is not the subject we're talking about today. What I want to talk about today is we're both alive. Maybe you've both done really good estate planning. You both have wills with asset protection trusts in them. You have really good, robust, durable powers of attorney, and you're working with an elder law attorney. You've done all that groundwork. You've done that. Now what happens? Well, somebody gets sick. And in this example, we're going to talk about a married couple, Mark and Mary. They've been married for many years and they have an estate that's worth $800,000. And what's happened now is that Mark has had a stroke and he needs high level of care, that skilled nursing facility care, and it costs $12,000 a month. That's $144,000 a year. And if that goes on for a long time, anybody is going to feel the strain of seeing those kind of bills be paid every month, month after month. The good news is I will be showing you that this couple does not need to go broke. So let's dive into the facts a little bit more. I said they have 800,000. What does that consist of? Consists of their house, and it's worth 300,000. As you know, that house is exempt. It doesn't count. You take that off the table for what's countable. Now, everything else is going to be countable. Mark has a Roth IRA of 150,000. Mary has a 403B of 100,000. They have stock portfolio of 200,000 and they have 50,000 in the bank. If you add that all up, that's 800,000, 500,000 of which is countable. Because he's going to skilled nursing care, the state is going to allow them to keep some money, but not 500,000. They're going to be able to keep the 130,000 some odd dollars that is the community spousal resource allowance and the 2,000 that the ill spouse can keep. So if you add that all up together, if my math is somewhere close to being right, they've got $368,000 too much money. What should they do? Well, I can tell you what most people do is they spend their money because they don't know that there are other options. So they just spend their money month after month after month. That is not necessary, and it's certainly not what I recommend. So what we would recommend for this couple is that they use their money wisely. And it's kind of counterintuitive. When you are facing a $12,000 a month nursing home bill, we're likely going to be telling you to spend some money because we know that to qualify for Medicaid, there is a resource standard we need to meet. So spend your money in a smart way. If your car doesn't work well and you're the well spouse, get a car that's reliable. If you don't have irrevocable prepaid burial plans, buy them. If you need to improve the house, do so. Do the things that you've been putting off because you didn't want to spend your money. Now's the time to do it. And then pay for professional legal services. What I'm about to show you does not come for free. So you need to pay for legal services, or there may be care management services. There could be services that is kind of difficult to pay for because in the past you've looked at them as expensive. But what you'll see is that by paying and investing in legal guidance and professional services, you're going to have a very good result, an excellent outcome. So spend the money. So in this case, we're going to have them spend money. I'll go over it in more detail. And then what we are going to do is take the excess money and put it into what's called a SPIA. It's a single premium immediate annuity. And it's the annuity that Medicaid allows you to have to take what is money. In this situation, $330,000 too much because they spent down 38 on various purchases and investments. They still have 330,000 too much, more than what the state will allow them to keep. So what should they do with that? Should they keep spending? No. They should buy a Medicaid qualifying annuity. And there's very specific rules about what is a Medicaid qualifying annuity. As you can see, it has to be immediate, means it starts paying out right away. Irrevocable, you can't change your mind on it. It has to pay out over a 5-year period. That's the state of Washington's rules. Other states don't have that rule. But everybody has the rule that the state of Washington or the state wherever the care is being delivered must be named as the beneficiary, contingent beneficiary. That means the beneficiary after the annuitant. I'll describe that in more detail. The really important thing to understand about this SPIA is that it takes what is countable, money, and makes it non-countable, a Medicaid qualifying annuity. So these are the special rules. If you have an annuity right now, you do not have a Medicaid qualifying annuity, unless the reason you got it was you were working with an attorney and your spouse qualified for Medicaid. So all the annuities that most people have are intended to give you income streams, financial security, prepare for retirement so that you'll have enough money. This Medicaid qualifying annuity is a whole different animal than that. I would be confident in saying that nobody in the listening audience here has this unless their spouse is on Medicaid or you're filing for Medicaid with the help of a lawyer right now. Okay, so let's talk about how do we get Mark on Medicaid and keep for Mary all the assets. We have to transfer all assets to Mary's name. That includes the house. That includes the money that was in Mark's Roth. Fortunately, it was a Roth, so we can do that without tax consequences. All of, Mary had a 403B that can be annuitized, which would be different type of, it'd still be a Medicaid qualifying annuity as well, without tax consequences. So basically we put everything over into Mary's name. Stock accounts, the bank, everything goes into her name. Then we take and Mary buys this annuity for $330,000. Remember, that was the extra amount of money she had. Then we file for Medicaid and Mark is approved for Medicaid benefits. And Medicaid will pay for Mark's care in that skilled nursing facility. Mark's income will need to be participated or contributed to his care costs. Let's say his income was $2,000. That's going to go to pay the care facility. But the extra money, whatever his income doesn't cover, Medicaid will pay. What's really important also to understand is that Mary does not need to contribute her income, not her regular Social Security income, and not the money that she gets month after month after month from this annuity. So if she put $330,000 into this annuity, it's a 5-year annuity, that's 60 months. Doing the math, she'll go back $5,500 every month. She gets to keep that money. She can put that money into savings. It can continue to accumulate so that she gets all of that money back and none of her income, none, goes to pay for Mark's care. So what this means is that this couple didn't need to deplete their assets. This is a couple that had $800,000. Yes, they spent down $30,000 some odd dollars because they needed to. It was, deferred maintenance. But the rest of it, they were able to keep all of their money. And the good news is that assuming Mary survives that 5-year annuity, the state will get nothing. Now, let's say for some reason Mary doesn't survive. She dies during the term of that 5-year annuity. Remember how the state was named as the contingent beneficiary? The reason for that, and one of the reasons the state allows this annuity, is that they know if there is no community spouse, because Mary has died, then the state will be able to recover from that annuity the amount of the benefits that they paid for Mark as of the date that Mary died. So that's the drawback. In terms of the planning options and what it allows, it is certainly important to be aware of, but a very small drawback. So that's how a couple can keep all their assets. So if you're ever told by anybody, including lawyers, you have to spend all your money, the state only allows you to keep this much money, and they don't even go over this type of discussion with you, you know you're in the wrong law office. And if you have any friends or family or anybody who's in this situation and they don't know what to do, there is help for them. There are elder law attorneys who know how to do this. We help clients do this every day. And I do have to mention that when somebody is going through this situation, they're dealing with not just this, how do I protect money? They're concerned about finances. They don't know if their legal documents are good enough. And they're dealing with the overwhelming stress of their loved one needing high-level care. I mean, this is a very, very stressful time in people's lives. It's important that people understand there are attorneys who can help them get through this really crisis situation. Again, we far prefer that people have their estate planning documents done well in advance so that we don't have to combine this kind of a Medicaid asset preservation strategy service with doing their estate planning documents, assuming people still have the capacity to do so. We really prefer that that be done in advance, but sometimes it's not done. Just know that there are attorneys that can help in this type of crisis situation. Let's move to single people. Couples have a pretty clear-cut strategy that is not that, as I've explained, they can keep all their money. Singles are not in that same boat. Before I get to singles, there is a question in the chat I want to answer. The question is, if Mary predeceases Mark, does this then make all of the remaining assets subject to Washington's clawback rules? Great question. The answer is no. Washington does not get to keep these assets. If Mary has them in her name, Mark's still alive, he is still on Medicaid. The only asset that the state has any interest in is that annuity. The annuity payments of $5,500 a month will go to the state of Washington until the amount of the lien that is set as of the date that Mary died, until that's paid off. Let's say Mary died at 6 months. There's only going to be 6 months of care that the state of Washington is going to recover against that annuity. The rest is going to go to whomever Mark and Mary said it should go. Let's say they have 2 kids. How about the rest of the assets? The question is focused on, well, what about the house? What about the bank accounts? What about the other money? Does the state have clawback rights to that? No, they do not. Caveat, however, if Mary had a traditional will, a will that was not done by an estate planning elder law firm, what will happen is, if Mary has what we call an I love you will, which says, if I die first, Mary says everything goes to Mark. That's a really bad situation, because what will happen is that Mark will receive all of these assets unprotected, and he will be bumped off of Medicaid until he is spent down to nothing. What that means is that no, in answer to the question, the great question was, no, the state doesn't have any clawback rights because Mary died. But if Mary has the wrong estate planning documents in place that don't protect assets, that don't create a trust through her will to benefit Mark, then it's not a state recovery lien situation. It's Mark's bumped off of Medicaid till he's spent down to $2,000. Again, I keep going back to why it's really important to have the right estate planning documents in place. And again, if you are working with an elder law attorney, they will be talking to you about, okay, we can do this Medicaid strategy, but we do need to correct your estate planning documents to ensure that the state gets no money that they don't need to get. Great question. Let me see if there's any more questions about couples before I move to singles. Question is that Roth IRAs were mentioned as being countable. How about regular IRAs? Yeah, everything. The general rule, there's always exceptions, but here's a general rule. In the state of Washington, IRAs, 401ks, 403bs, non-Roth IRAs, it's all countable. If you're in a different state, like Idaho, there will be different rules. But in Washington, the rule is every type of retirement fund you have is countable. All right, Medicaid asset preservation strategies for a single person. Remember that a single person can have a house and $2,000 and that's it. Well, they can have a car. So let's take Darlene, and let's say Darlene is a widow. She has been living in the family home after her husband died, and she and her husband didn't have asset protection estate planning in place. So that's why we're dealing with Darlene being the owner of all the assets. And she is going to need, she's going to need to move out of the house and into an adult family home. Adult family home is a facility, it's a care facility. They have up to 6 residents. And it is a very, very good option for people to receive care that isn't the highest level of care. The cost of care at the adult family home is going to be $5,000. Remember, this is an example, a scenario. This isn't every adult family home cost of care is $5,000, obviously. Darlene's income is $2,000. The difference between the $5,000, what it costs to be at the adult family home, and the $2,000 that she has in income is $3,000. That's what I call the cost of care deficit. So she's going to be short $3,000 every month. She's going to need to dip into her savings. She has a house that's worth $250,000. She's got $75,000 in the bank, and she's got $20,000 valued car. That's all she has, and $2,000 of income. So you can see that she is going to run out of money after a couple of years, and then she'll be on Medicaid. And then if she doesn't do anything about the house, the state will end up getting the house and the car. One of the things that I want to point out on this scenario that I included is that this adult family home has a private pay period of 1 year. You need to be aware that adult family homes and assisted living facilities generally have private pay periods. 6 months, 1 year, 2 years, 3 years. When you're doing planning with the attorney and when you're thinking about this for yourself or for a loved one, keep in mind that there likely will be a private pay period. 1 year is considered a shorter private pay period. So that's the scenario with Darlene. What are we going to recommend for Darlene? Again, we are going to recommend that she use her money wisely. She's got $75,000. We know that her adult family home has a 1 year private pay period. We know that she's short $3,000 a month. So she's going to need to dip into her savings $3,000 a month over the course of the year. That's $36,000. That's what we're going to be doing primarily with her $75,000 bank account. Because she has a 1 year private pay period, we're going to want to make sure that after 1 year, she will be eligible for Medicaid. And how we do that is we spend her money. She is going to be spending her money on legal services and other goods and services. She's going to spend $10,000 on a burial plan that's irrevocable. And she is going to spend $15,000 to ready her house for a future sale. And you might be thinking, well, this is making no sense. Why is she putting any money into her house? She can't live there anymore. She's at the adult family home. That's right. But we keep this house as an asset that we can use. She's going to file a notice of intent to return home to keep that house non-countable. And if this is getting complicated, I get you. I hear you. I'm sorry. I do a lot of Medicaid applications and strategies. So there is a lot of information. When I do, estate planning discussions and other ones, it's more straightforward. Medicaid is this crazy set of rules you have to know, and when you know them and you comply with them, you can get a really good outcome. But you need to know what the rules are. So my apologies if you're going, man, my head's about to explode. I understand. So we're going to do this spend down. She's down to $2,000 because she did all that spending. And after a year at the adult family home, we are going to apply for Medicaid. The adult family home will accept Medicaid, and she is now at the adult family home, and Medicaid is paying for her cost of care. That, remember, again, her income goes towards her cost of care, but Medicaid, the state will pay the rest. I don't know if you recall, but earlier I said that if you're a single person, it's really hard to avoid estate recovery. I'm going to show you how to avoid estate recovery. Don't recommend you do this on your own, however. So what we're going to do, we are going to transfer the car to her child. Why? Because we can, no penalty. That preserves the value of the car, no penalty. Then what are we going to do? Well, in order to make sure that the value of the house doesn't all go to the state when Darlene dies, we're going to sell the house. And because of all the improvements and everything she did to that, we're going to net $250,000 from the sale of this house. What are we going to do with that money? We are going to have Darlene keep $60,000, and we are going to have her give away the rest, $190,000. What happens next? Well, there's been a change of circumstances. We have to tell DSHS, that's the agency that administers the Medicaid program, what's happened. The that the house has been sold, that Darlene kept $60,000, but she gave away $190,000. And they're going to look at that and they're going to go, oh, you gave away $190,000. Well, then we're going to apply this penalty divisor of $10,785. And as a result, there'll be 18 months when Darlene will be private pay again, off of Medicaid. So she was on Medicaid, and we bumped her off of Medicaid because we sold the house and we gifted a large amount of the proceeds, and we had her keep $60,000. So she's off of Medicaid for 18 months. What's next? Again, it's kind of a math equation. She's short $3,000 a month. She's off of Medicaid for 18 months. For those 18 months, she's going to use that money that she kept, the $60,000. And over the course of the 18 months, $54,000, which is $3,000 a month, times 18,000 equals 54. That's going to pay for her care at the adult family home. There's a little bit extra there, $6,000 over this 18 months that she's going to spend on various items. But at the end of the 18 months, she's going to be down to $2,000. What happens when she's down to $2,000? You file the Medicaid application again. She's back on Medicaid. Okay, so we did a lot of work. Why did we do all this work? Because rather than her having nothing and her family having nothing and spending down every dime and having the state get her house, we were able to preserve $190,000 in assets plus the car. That's what we can do with a Medicaid strategy for a single person. So what I want you to know, with all of this data and rules and everything, to try to lighten it up a bit, yes, you absolutely can protect assets. There is a way to do it. Talk to an estate planning, elder law attorney who knows Medicaid asset preservation strategies. If you're interested in speaking with us, we're always happy to talk with you. We're Elder Law Group, ELG Estate Planning. There's our contact information, which is 509-468-0551, or email us. I mentioned that we are going to be sending you, for those of you who stayed, thank you very much. We're going to be sending you not only the Medicaid's rules, but an ebook on the couples strategy that I explained, the single strategy that I explained. And if for some reason it doesn't get sent to you, just reach out to us. We're team@elgwa.com or webinar@elgwa.com, or just go to our website, elgwa.com. So, that was a lot of information, I know. Thank you so much for staying with me. We're going to send you information. I tried not to confuse everybody. I hope I didn't. Before we wrap up here, I want to make sure that I answer any other questions that are in the chat. There's questions about gifting and whether the gifting can be placed in a savings account or an investment account to benefit the single individual. By that, I think they mean the person who is on Medicaid. The answer to that is that the gifted funds are not needed to care for that person. So yes, those monies can be used for any supplemental benefits. Remember, under the strategy with a single person, they kept enough money to get through the period of ineligibility. But there's a lot of rules that have to do with constructive trust and this and that, and I don't really want to get bogged down in that. It could be gifted to a person outright, to a trust, for other family members. There's just a lot that can be done. And frankly, who we gift to and how we protect the assets really depends on the family dynamics, the family situation. When we're dealing with a single person and doing that kind of a strategy, we'll never do it if we have this dysfunctional, litigious family where everybody's pointing fingers at each other. That's just not the appropriate place to be doing a strategy like this that really involves cooperation with the family, trust, and the family being more functional. One of the things is that we'll never put people in a situation where, you know, they're going to have to fight against adult protective services. We're always there to help people when we do a strategy like this. Okay, well, I think that is the end of the questions. Thank you everybody for staying with me. If we can answer any of your questions, just feel free to reach out to us. Again, I'm Lynn St. Louis with ELG Estate Planning. Thanks again.